think so, yes, we will, yeah, because then we will have more time for discussion. So we will meet. So, Alexander. Okay. Then we have Monika Stachowiak. Excuse me. Karolina, dobrze. A Monika Stachowiak? To jeszcze minutkę poczekamy. Okay, sorry. Just with the Polish name you speak Polish, no? So that's... Okay, welcome everybody. I'm moderator of this session. This session in this European Union and its institution, law and economy block. And today we were supposed to have 4 panelists, but Aline Beltrame de Mora, she couldn't come, but she registered her her talk, and it will be available on our website after the conference. And so today we will start with Aleksandra Borowicz from Gdańsk University, FDI screening system in the EU, overlapping of competences between MS and EU institution. Just please go ahead.
Okay. Hello, thank you for the invitation for today's panel during our conference. My name is Aleksandra Borowicz. I'm from University of Gdańsk from the Department of European Integration Research. My main interest is European integration and generally international economic with special focus on FDI. It was a part of my PhD thesis. The linkages between FDI and foreign trade. And I think that since 2017 there was a little of bit dynamics in terms of FDI in European Union, and in 2019 there was a implementation of FDI screening mechanism towards foreign direct investment in European Union, and this is why I decided to prepare an article and a speech in this area. I'm not going to convince you about the effects, general effects on FDI, why economists are interested so deeply in these terms. However, since the FDI were one of the main forms of capital that influence globally in terms of capital, it is worth to underline that European Union is still, since decades, a leader in global foreign direct investment in terms of outward stock and inward. Of course, the situation is a little bit changing since a few years, let's say since 15 years, as the emerging markets and developing countries are trying to build their strong position on this global, in this global puzzle. What is more, we discuss FDI mainly in terms of those positive effects, but we have to be aware of the fact that this strong position on FDI in terms of economic development is mainly determined by the internal situation of the hosting country of FDI. And in 2008 there was a very strong discussion on the FDI, which was introduced by Mats Forsgren, who called even FDI that can be beauty or the beast, depending on the absorptive capabilities of the hosting country of FDI. So we see FDI as the channel of transfer of capital, of the technology, the strong involvement in the local economy in terms of labor market, but also of the in terms of creation of production change and also as a becoming in local economies some kind of hub which creates some additional value added to the local economy. But as I said, the European Union since many decades is the global leader in terms of FDI, as well as bringing to the world of FDI, but also in terms of receiving. If we look at the chart with some data on this shares that EU is part of this global cake, let's say, since 1990, the share of EU in terms of inward stock was strongly declined. Let's say it's about 10%, but at the same time, emerging markets, especially with great attention to China, strongly developed and changed. However, we see this 2016 when something radically changed actually in the position of China. I will discuss this a little bit later. In terms of outward FDI, we have very similar situation, but in terms of US, we have more stable situation. So their position in this global issue connected with shares of FDI is more stable. Why EU decided to put a lot of attention and to draw attention of member states to the foreign direct investment? We have to remember that foreign direct investment was one of the first forms of the free movement of capital, because already in 60s of the previous century, FDI was generally liberalized on the basis of directives by European Economic Community issued. So it was the area that was in the center of the interest of European politicians. But 2016 brought some kind of new attention to FDI, especially from three countries. It was France, United Kingdom, and Germany, who wanted to show how strongly is penetrated the European market by especially Chinese capital. So we have those data from 2016, and we have that non-EU owned companies represent circa about 9% of companies that are listed on stock exchange, but at the same time they represent more than 45% share of assets that are in those companies. So the value added that they bring is very strongly dependent on the size of the entrepreneurs and companies, which mainly we know that China investors that come to European market somehow are financed from public sources, which changes radically the position and competitive position of European companies and those which are under the FDI influence. In terms of unlisted companies on stock exchange, we have this even more radical situation, because it's only less than 3% of companies that are non-EU owned, but they represent more than 30% of assets in this part. Chinese capital, which is strongly developed in European countries. The situation has changed in 2016, we can say that at the beginning of 2017, because there is a global change in the system towards FDI. And not only Germany, France, and United Kingdom put some attention to their system of screening of FDI, but it was the general activity in European Union. So the control and monitoring of FDI started to be a strong part of economic actions on the member states level, and we see that it has a result also in the value of completed Chinese FDI transactions up till 2018. There was a dynamic discussion on FDI in terms of their place between competences among the member states and European Union institution. The Treaty of Lisbon developed and put the FDI in terms of their place among the common policies in the area of common commercial policy. So it means that FDI are defined as an exclusive competence of the European Union. So basically it means that the law in these terms is created and implemented in Brussels by European Union institution. But it's for us not that obvious actually that foreign direct investment is a part of common commercial policy. However, the portfolio of tools and areas under the common commercial policy proposed in the Treaty of Lisbon showed that there is not only, the commercial policy is not only based on the services and trade general, but also it touches the problem of intellectual property and also foreign direct investment. It is a result of these global processes that take part in European Union. European Union is very active since, let's say, 10 years in terms of writing and negotiating international agreements in the area of trade, but also in the area of international investment agreements with third countries. So this is the main reason why the FDI are the part of exclusive competences. But at the same time, we are dealing since few years with a new phenomenon in European Union, which was also in the literature discussed mainly by lawyers. This is so-called mixed agreements, which involve European Union level decision-making process, but also member states. However, the European Commission is responsible for the negotiations and preparing the international agreements in terms of investment and also in trade. But in case of mixed agreements, finally, they're always proposed also on the national levels, and member states independently decide on the ratifying and implementation of those agreements. During the process of negotiation, European Commission very often consults, of course, the main areas with member states, so there is no place, of course, for surprising member states. So finally, I have only, I think, 1 or 2 slides. Only one. What is the FDI screening mechanism? A lot of experts in this area wrote that this mechanism will be based on a good practice coming from US, Japan, or Canada. However, it was changed. The procedure of the implementation of FDI screening mechanism was quite quickly as for the standards in European Union. The discussion was initiated in the second half of 2017, and now in the April, the implementation was, the law was ready. What is the target of FDI screening mechanism? Those are the crucial areas of the European Union development, such as research under the Horizon 2020, investment in areas of key technologies like space or IT, and also trans-European networks. So it means just generally that FDI screening mechanism will be some kind of monitoring system and cooperating system between member states and European Union. So in terms of my, let's say, hypothesis, is it a mutual support or the overlap of competences? I would like to underline that it goes to in the direction of mutual support. As the key fact we have to remember about the FDI screening mechanism, that it means that it uses main instrument in terms of integration. It's consultation between European Commission and member states. The FDI screening mechanism also bases on the exchange of information between member states. So the member states from other parts of the European Union will have the opportunity to analyze also effects of the incoming FDI to the, for example, neighboring country and somehow support the system. But finally, in terms of welcoming the FDI, it will be the independent decision of each member state. Are we willing to be open for this foreign direct investment, or we are resigning from this project? Just short remark about the system which works in United States. Of course, they are more developed in legal instruments in terms of U.S. government. The committee, let's say, in 2009 and between 2009 and 2014, rejected only 7% of investigated projects in United States. So it's circa about 7% during 5 years. So I hope that somehow European Commission will develop this instrument more deeply, actually, and give furtherly more instruments to European Commission to support finally the member states. Thank you very much.
Thank you very much. And now I would like to ask Monika Stachowiak-Kudła from Warsaw University of Technology, transnational judicial dialogue in case law related to academic freedom. Now, it has to be very interesting. Yeah? Thank you. Just 1 second, please. We have some difficulties with the equipment, but we will start shortly. We're ready. Please.
A transnational judicial dialogue is a metaphor for the comparative analysis found in judicial decisions. It may manifest itself in the court referring to the judgments of international tribunals and constitutional court in interpreting national human rights guarantees, in invoking international conventions, invoking the doctrine of another state, or in pointing to the foreign law. Academic freedom is a defensive right. It protects scientific and teaching activities against the inference on the state and another authority, including university and faculty authorities. The countries where a given right or freedom is not expressed explicitly in the Constitution, or does not have a legal definition, or there is a dispute as to the essence of these rights and freedoms, constitutional courts will be more likely to rely on international convention and jurisprudence of international tribunals and constitutional courts of another state. The constitutional courts are also more likely to recall the legislative solution of another state in difficult or controversial cases. The article analyzes 100 judgments from the Constitutional Court of 10 European Union countries referring to academic freedom. In some countries, academic freedom does not have a legal definition, and in the event of the dispute, court have to determine the essence of this right. The inclusion of the countries where the legal definition exists made it possible to examine whether the intensity of transnational judicial dialogue depends on the position or absence of a legal definition of a given right. Disputes in which the Constitutional Court resolved the issue of violation of academic freedom are rare. Most often, academic freedom is cited in the background of a dispute about another right. A small number of academic freedom judgments indicate that this is not a right which causes a lot of tension. However, if such tension do appear and are presented before a constitutional court, they are often hard cases. According to David Fontana, the comparative constitutional law is justified only in hard cases, when constitutional sources of law do not provide exact answers. The first category includes cases referring to the collision of principles. Academic freedom can conflict with both the individual rights, such as the right to respect for a private life, or with institutional rights such as university autonomy, on the right of the church to self-determination. Academic freedom does not have such a strong position on another principles. The second category of hard cases appear in countries in which the source of law do not provide specific answers. This happens when one of the parts of the academic freedom is not guaranteed in the Constitution, there is no legal definition of academic freedom, or there is no agreement as to the essence of these rights. Most often, courts cite international treaties and least often cite the Court of Justice of the European Union and quoted the doctrine of another state. Transnational judicial dialogue has been observed in 6 countries: Belgium, Czechia, Poland, Portugal, and to a limited extent in Germany and Spain. Reason for judicial dialogue: support for their own interpretation. It explained the procedure of conflict resolution, challenged the validity of the lower court's arguments, strengthened them, and otherwise uncertain arguments. Reasons for transnational judicial dialogue in international treaties are different. The discussion on international law was treated as a reflection on domestic law, to supplement incomplete legal regulation, to resolve ambiguity in specific human rights regulation, to distinguish the scope of certain restrictions on human rights in domestic law. Of the 18 cases in which we observe transnational judicial dialogue, 5 belong to the first category of hard cases concerning collision of principles. 6 should be classified on the second category concerning the situation in which the source of laws of constitutional and statutory significance do not provide specific answers. An analysis of this case law has shown that only some countries use the case law of international tribunals and constitutional courts of another countries to interpret the national guarantee of academic freedom. The intensity of transnational judicial dialogue in case law related to academic freedom should be assessed as not very widespread. The case law analysis in this paper allowed to find two additional reasons for starting a dialogue not provisionally indicated in literature. A judge may use foreign case law to challenge the validity of arguments put forward by another court, or the judge uses foreign jurisprudence because it contains a description of the procedure for resolving a given type of case which is missing on his home court. Judicial comparativism is justified only in hard cases. If there are convergent decisions on similar cases, the court should present them. It should not limit itself to quoting those that are consistent with its vision of resolving the dispute. The court should explain why one of this model is chosen. Thank you very much for your attention.
Thank you so much. And now I would like to ask Karolina Koenig from Adam Mickiewicz University in Poznań, harmonization of EU criminal law, the thing about implementation of EU directives.
Thank you very much for the invitation. I'm a PhD student from Adam Mickiewicz University in Poznań. The thing about implementation, we can say that one of principal aims of European Union when it comes to law is harmonization of laws. So EU directives set mutual standards, and member states are obliged to implement them in their own ways. Two main problems can be recognized on this field. Firstly, member states do not implement the directives or do not implement them correctly. And secondly, they implement the directives in different ways. So, as a consequence, we still have 28 different legal systems, and the goal is not achieved. The right to an effective remedy when it comes to criminal procedure sets the perfect example, because 5 EU directives aimed at enhancing the rights of accused and suspects include the right to an effective remedy in the event of breach of any provision of the directive. The problem is that the definition or even a common understanding of the term of effective remedy does not exist. So how are we supposed to correctly implement it? I know that we are short of time, so I will limit my presentation to the best example, I think, the directive 2013/48. This is the directive on the right to a lawyer. And I will try to show how the right to an effective remedy on this example was implemented into the Polish legal system and the other systems of member states, and then try to answer if the implementation of directives is a correct tool to harmonize law, and what solution can we find. So two main rights under this directive on the right to the lawyer are the right to immediate access to a lawyer and right to confidentiality in contacts with your lawyer. When it comes to an effective remedy, the directive says, I will quote it, that Without prejudice to national rules and system on the admissibility of evidence, member states shall ensure that in criminal proceedings, in the assessment of statements made by suspect or accused person or of evidence obtained in breach of their right to a lawyer mainly, the rights of the defense and the fairness of proceedings are respected. So still no definition and no common understanding, and actually the definition was in the text of directive on the stage of commission motion, but then during the legislative works the member states did not agree on that, so still we don't know how it should look like and what forms can it take. And the results as follows. According to the information of database of European Commission, this directive was fully implemented to the Polish law by 5 legal acts. However, we should really consider then in reality no changes was taken, and this directive was not really adopted. The Amendment Act aimed at adapting the Polish law to the requirements of the directive was withdrawn due to the fact that this is the quote, the Ministry of Foreign Affairs confirmed the compliance of Polish law with the directive and there's no need to implement it. Similarly, representatives of the Ministry of Justice indicated that a detailed analysis of the provisions contained in the directive and the corresponding national regulations was carried out. It led to the conclusion that the Polish law currently fully reflects the postulates of the directive and therefore there is no need for adaptation measures. It is contrary to the statements of the courts, the doctrine, the academic statements. So we really should consider that this was not implemented at least correctly into our Polish legal system. We don't have any prohibition on evidence in our system regarding the use of evidence obtained in breach of a right to a lawyer. No restriction on that. The CPP, the Criminal Procedure Code, says clearly indicates that evidence obtained contrary to rules of procedure cannot be declared inadmissible, and there are lots of demands from the doctrine and the courts, the judicature, to maybe introduce some kind of exclusionary rules of it, maybe adjust the jurisprudence line directly based on the directive or the case law of European Criminal European Court of Human Rights, but still we don't have any measures. In terms of confidentiality, it can be the confidentiality of contacts with lawyer can be the restriction can be imposed on that by the prosecutor, and it's not subject to any appeal. What is clearly contrary to the directive, but still nothing with that. And it should be pointed out that effective remedies in the event of breach of right to a lawyer adopted by the member states are extremely diverse, extremely. 23 member states have the exclusionary rule and do not accept evidence gathered in the way that breaches this right. 2 member states has the rule of the inadmissibility of prosecution in that case. We have states in which charges are dismissed and accused is acquitted. We have states when reducing of statement is possible. The most popular one is the annulment of the court judgment with possibility of the retrial. And all above mentioned remedies exist in different ways, under different conditions, with different changes. But all of these member states says, yes, we have fully implemented the directives and everything is okay. So this really calls into question the effectiveness of the implementation. It calls into question the goal of the common minimum standards, depending mutual trust and mutual cooperation, recognition. How can we assume that the right to a lawyer operate in the same way in all member states, since the remedial measures vary a lot from the adoption of doctrine of the fruit of the poison tree, the exclusion of evidence, mitigation of judgment, resuming the proceedings. Unfortunately, Poland is one of 5 countries providing the weakest protection, so we should still consider it. To sum up, it can be said that presented directive was not implemented correctly into the Polish legal system, and this is the case in really many member states. So the directives are implemented only partly or are not implemented at all. We should think, so what now is the harmonization? The directives are the correct tool to harmonize the European member states' law. Thinking about the remedies, we should consider maybe enhancing power of European Commission, the power to hard verification of the state of implementation, maybe with imposing further sanctions. Or maybe we should consider if this multi-language concept is really good because now all of 28 language versions of legal acts are considered as official. It is a problem because some terms are not understandable, we cannot translate it correctly, and then member states just do not understand the obligation under the legal acts. Maybe we lack references when it comes to the directives, so maybe we should consider if the preambles, which are often longer than the merits, should include some clear guidance or explanation how we or how the member states should understand the terms, the provision, and how possibly or like for example should implement it. So for now, thank you very much.
Thank you so much. And now we can start discussion. Who would like to ask the question or just some remarks about our presenters? Yes, please.
So I would like to address my question to the first speaker and to Madame Borowicz. Okay, so you were discussing about foreign direct investment.
Yeah.
And then it was a title related to China.
Yeah.
So I've seen on the statistics that it's decreasing.
Yes.
Foreign direct investment.
Why is that? I said that it was the FDI transactions value in European Union up till 2016, especially 2010, 2016. There was a great increase in the general number of flowing FDI from China. But the end of the 2016, let's say, closed some era in European Union because. As the European Commission started working on the FDI screening mechanism in 2017, also member states tried to review their own systems because FDI screening mechanism is nothing new. It is also a tool which is generally used on the level of member states, but only in 12 cases. So mainly United Kingdom, France, Germany, Italy were those countries who were interested in supporting their actions on the national level by actions on the European level. So just the activity towards those screening mechanisms and changing their internal law has resulted in that already the transactions that were planned for 2017 and 2018 in European Union already decreased. So China had to face globally, not only in European Union, with the fact that developed countries like Canada, Japan, United States are trying to be more independent in terms of welcoming the FDI. So they wanted to protect their own companies as the engagement of the public financing in Chinese FDI generally. Because usually we have to deal with the multinationals from China in the form of private equity, but behind those phenomenon very often is the public financing, because FDI is one of the key elements of the Chinese penetration, technology gaining in developed countries. In the era of digitalization, exchange of information, going into high technology industries is crucial for almost all countries. So they, through the FDI, they just want to transfer technology, the know-how to China. So this is why also developed countries put a lot of attention since few years on those monitoring systems, because China capital just strictly is able to make the situation more complex and not safe, let's say. So it's not safe for the stability of global world for now.
Yeah, more question? So may I ask? So I have a question to Monika. Monika, what is about academic freedom in Poland? Are there any judicial cases related to Poland, or how is this academic freedom protected in Poland? And I have a second question to Karolina, because you mentioned about these obstacles to the harmonization. I know how difficult it is. And what are the major obstacles to harmonization? And I just one remark, because I studied this harmonization of law in Canada, and you know, from 1867 they started this harmonization process, and it's still on due to the two languages, and in civil matters you have two different jurisdictions as well. So it's really challenging for a country with two legal systems, and so if we have 28 legal systems, how to do it? So can you identify just the major obstacles that are related to? More question? Maybe we can. So then our guest will. No? Okay. So. If we don't have no more questions, so please go ahead. Maybe we will start with Monika.
Okay.
Yeah?
Okay, so I will start.
Karolina.
So I think this is the problem about the fact that the member states simply are not willing to adjust that, the legal system. Okay, this is the thing about the autonomy of the states. That sure we can say that the European Union represents all of the interests of countries, but simply sometimes they just are not willing to do it, and the member states. It's about the autonomy, but also about money. That, for example, implementing all of the provisions of the directive, what I was talking about, is really expensive for the country because of the system of free legal help, which is paid by the country. So I think that there are lots of problems, but mainly I would say about the autonomy of the state and not willing to do that.
Okay. Thank you so much. Yes, more questions, please.
Just to follow up from what you just said, my name is Eva Żelazna, I work at the University of Leicester. With this specific directive, do you think that this will create a potential for individual challenges? So citizens try Thank you. Could this type of action provide an incentive here to be more willing to implement provisions of the directive?
Yes, the deadline of implementation has been, I think, 1 year ago. So now the individuals can claim directly to get these rights from the directive, like just without the Polish procedure. I work at the criminal courts, and I didn't hear about it. I didn't hear the single case when individual claimed the direct effect of the directive. But obviously it could be the signal or the point to enhance the country to implement it.
More question? Okay, well, I will discuss the issue. And you would like to speak in Polish, then I can translate.
Thank you for the question. Przykłady polskie dotyczyły tego, czy w przypadku, kiedy wolność akademicka dotyczy każdego, to można prosić o specjalne pozwolenie dla ludzi, którzy nie są z uniwersytetów i nie zajmują się działalnością naukową na co dzień, albo od dziennikarzy, na robienie badań naukowych w niektórych instytucjach.
Okay, so there were cases, and one of those, it was that if the journalists can work within the scholars' facilities at the universities, and they are protected under the academic freedom. If you don't have, we almost ready to go for next coffee. So thank you very much, and thank you for our presenters, and see you in half an hour in other auditorium. Thank you so much.
What time is it? So we will start in 3 minutes. Yeah, you can start that. So there are like 2 people for 1 hour, but because Alex is also not here, so there are those 2 ladies. Yes, but 2020 it's still 40, so there's still 20 minutes. 20 minutes. So we will finish early. Is it okay? Yeah, it's fine. If Anna
Okay, sorry to disturb you, but we still have to wait for a few minutes because another session still lasts, so we will start as soon as they finish. That will just be in a moment, okay? Thank you. So this session's here.
There's two people here.
Only two?
So Mr. Moldovan is not here either.
So only Miss Marga, you
And
are
Marta told me to give them 20
Miss
minutes.
Godleska.
Yes.
Okay.
Yes.
Nice to meet
To
you.
give them 20 minutes.
And Miss Żelazna, yes?
Yes.
And what about Anna Bizbici? She was here.
But she's meeting with the dean. Marta told me, and maybe she will not manage to come, and she will be moved to another panel.
And maybe some from another panel. Marta is the organizer. Where is she?
Marta was here, and she told me that Mrs. Bijbizi is in a
What is the
meeting.
topic of your which institution met for the race?
Probably she will manage to come because she's the last presenter, so she will arrive.
Maybe I will send her SMS right now.
But she's in a meeting with the dean of the university, so that's why she was late. Marta told me. Okay.
I will try to get in touch somehow.
Okay.
Okay, just let's wait because they will come in a moment. Please still I will check when it will finish.
What's that, sorry? I was at the WISIS conference in United Kingdom. Four people, and the third person was about to come also. She got sick. She was hospitalized in London. So instead of four people, we were just two. And we had 1 hour and a half. And they gave me 40 minutes. 40 minutes to speak. So I could deliver
Yes.
a presentation.
Yeah, I have also such example. It was in, I think, 2017 when something happened in London. So some people canceled their presence on conference. I was in Nottingham, and it was, I think, a few days after there was, I don't know, bomb in London or something like that.
2017, but in London it was in 2005.
No, 2017 there was something, and a lot of people, especially from the United States, they canceled. So
This person it was from Australia, my panel, and she arrived when she was sick. She had
now,
an emergency surgery, so that's why we were just two people, professor from Poland and me, instead of the full courses.
yeah, I also was in, I think, with one girl from Republic of South Africa, but the problem was that not only in our session, but in all session, conference, it should be, I don't know, 600 people, but there was only 300 or more, because only the last moment,
It's
sort of cancelled.
it was also in Oasis, and you know that it's the biggest conference in Europe these days, so I believe that like 20% didn't attend. across her presentation entitled Which EU Institution Matters for the Race of the Sharing Economy? You have 20 minutes.
Ladies and gentlemen, I have a pleasure to present my paper. First of all, I would like to thank the organizer for inviting me here. In the last 10 years, we are the witness, we may observe the rise of the sharing economy because the biggest platform of sharing economy, they were just set up in 2008 or 2009. And in the last decade, we may observe the change of the attitude of customers from the attitude of ownership of assets to the attitude of access to the assets. So when I need a car in the sharing economy, I do not have to buy a car. I may borrow a car of someone else, or I may join a car of other person who is going in the same direction as me. What was my motivation? So when the sharing economy started up, so it was 10 years ago, the market share of sharing economy in 4 leading sectors like accommodation, transportation, fundraising, or leisure was only 0.1%. And now we have the prediction forecast that in 2025, the market share of sharing economy compared to the traditional economy, it will be 50%. So the rise is very spectacular because, for example, Uber, who was set up in 2008, now is worth billions of dollars. Many of sharing economy online platforms are unicorns, so are now value more than $1 billion of United States dollars. And we have really problem with this sharing economy because most of them do not obey European regulation because in their opinion, these regulations are not for them, not for their business model, but for traditional model. The same problem is with taxes. Most of the biggest American online platforms of sharing economy like Uber or Airbnb are registered in Ireland, in Luxembourg. So in this country call it European tax haven, but they operate in whole European Union, but pay taxes only in Ireland or in Luxembourg. So we have also the proposition of European Union of digital tax. Unfortunately, till now only France introduced this digital tax, but there are many countries who want also tax these sharing economy platforms like for example, the Czech Republic or Italy, who will introduce digital tax from next year. But the problem with the sharing economy, there are not only American online platforms. Usually now in the European Union, we have also a copy of this American platform. So for example, in the United States, we have the most famous online platform like TaskRabbit, but in Poland we have a copy, Polak Potrafi. So in Europe we copy some of these ideas of United States and we have our own online platform. What was my main objective? So the aim of my paper was to investigate which European Union institution matter for the rise of the sharing economy online platforms, and particular focus was put at ascertaining whether the European Union legal institution would protect contractors as well as undistorted competition in the support of the development of sharing economy. So we know from the literature that institutions matter, and institution matters because they reduce transaction cost, and also they help to create destruction. So institutions help to destroy the old institutional settings which are not good enough, which do not cover this new model of business connected with sharing economy, and help to create new institutional setting which will cover the sharing economy. Also, we know from the literature that the most important are legal institutions, because when we have too poor quality of regulation or too flexible regulation, it means that we may have too much litigation. Litigation are very costly, so they should be avoided. So we should have such legislation, such legal institution which will help us to avoid this litigation, because legal system unfortunately is very expensive social institution. So what are my results? In my opinion, the most important is the Treaty on the Function of the European Union, because the treaty establishes the free movement of services, as well as guarantees the right of establishment and guarantees the fair competition in the European Union single market. And in practice, we have a huge problem with sharing economy if it is information society services or not. When we compare Uber and Airbnb, Uber and Airbnb, they deliver services like intermediary services of the real world exchange provided to peers by online platform. However, Airbnb, according to the rulings of Court of Justice, is deliver these services according to the Directive of Information Society Services, but Uber not, according to the Court of Justice of the European Union. The services provided by Uber are transportation services. So we have exemption from the treaty, and each country may regulate the policy according to the Uber in own country regulation. So, for example, in Poland, from the next year, we will have a Uber law. So the drivers of Uber will have to have a special permission, license. But for example, in Estonia, Uber drivers may choose if they want to have a license and use the special ways for buses and taxi drivers, or they may not register, do not have to have a license, and just stay in the queue as other cars, so they do not have any priority in the road. So it depends on the Uber drivers. We also have problems according to the free movement of services, that in some country, like in France, for example, if we will see Airbnb, that these platforms offers the services of accommodation. So for one side we have a host who have free flats, apartments, houses, and for other part guests who want to use these flats, apartment, houses, who want to rent them for a short period of time. But in some country, like for example in France, when someone wants to be a real estate agent, and France see Airbnb, their services, like services which are regulated in France, so you have to have special permission. And we have now in Court of Justice in European Union now one case which also tackle the free movement of services. That may be some other exemption that it will be, so Airbnb will be allowed to free deliver their services in European Union. But, for example, their providers will have to register as real estate agents. We don't have till now the final rulings. Other very important legal institutions are directives connected with consumer protection. So we have a Consumer Right Directive, Unfair Commercial Practice Directive, Unfair Contract Terms Directive. And we have also regulation on jurisdiction and the recognition of and enforcement of judgment in civil and commercial matters. We have in practice one decision of European Commission against Airbnb, because this platform, for example, in the past when present the offer for renting an accommodation, present only the price of the host, but do not present the end price, and only on the last stage of payment. This service added the obligatory fee of the platform, and this platform do not inform their guests who would like to rent these flats about the local taxes, which also, for example, in Poland we have some location in which we have to pay taxes for each day. We call it opłata klimatyczna, but it's not only in Poland. So Airbnb have to change this regulation, change the price policy. And also the other problems is with which law should be used according when we will have some litigation, because, for example, Uber is in Europe registered in Luxembourg, and if you have some case against Uber, so you can read on their terms and services that you should put this case against Uber according to Luxembourg law. We have other platforms who force their users, in case of any litigation, to go, for example, to the court of United States courts, for example, for California or from United Kingdom. But according to European regulation, when the client is the consumer, we should use the law of the origin of consumer. Other problems are according to the Treaty on European Union, which say that in Europe we should make all efforts which have the aim to the full employment and social progress. Unfortunately, the hosts of sharing economy platforms are usually contractors, not employees. In the United States, we have many rulings, many cases against, for example, Uber, that their contractors wanted to get a status of employees, but failed to prove. So in expert opinion, it may be in future when many economists say that we won't have traditional economy, all will be sharing economy, so we will have the army of contractors, and it may provide a precariat. Other problems is that the sharing economy platforms start to use technology based on artificial intelligence. So, for example, Uber is testing self-driving cars. Amazon tested using drones to deliver their packages. So they have such solution. And the problem is what will happen when sharing economy start to use this artificial intelligence technology on the daily basis. We don't have till now in European Union regulation which will help to solve such cases. According to the call of European Parliament, we should have till now a civil code for robotics and artificial intelligence, because in European Union we have a debate if artificial intelligence should get a status of electronic person. So we have like company, for example, be able to sue. We are not able to sue artificial intelligence per se. We may only sue producent, importer, designer of this artificial intelligence, but not artificial intelligence. But some solution may work independently, so it's a huge problem. So my final conclusion are that the legal institutions are the most important to develop the sharing economy, but also to protect the not only the sharing economy online platforms, but also consumer contractors and undistorted competition. And also we need to have regulation on European level, the same in the whole Europe. According to this artificial intelligence technology-based product, we should have this common civil code for robotics and artificial intelligence, but I hope that it won't be a directive, but it will be regulation that will have the force in all European Union member states. So thank you very much.
So thank you. As our second presenter, Mr. Alexei Moldovan, is not here, I'm giving the floor to Mrs. Eva Zelana from the University of Leicester to deliver a presentation entitled The Role of Women in Parliament in the Shaping of the EU as a Normative Power in International Economic Relations. They hear me.
Thank you very much. Good afternoon, everyone. Thank you very much to the organizers for your kind invitation. I always cherish an opportunity to come back to Poland and present here, especially that the food here is so much better than in the UK. So the title of my paper today is The Role of the European Parliament in the Shaping of the EU as a Normative Power in International Economic Relations. And three different aspects define the scope of this study. First of all, one of the aims of the Treaty of Lisbon was to strengthen the EU's position on the international scene. And the Treaty of Lisbon, the amendments it's introduced, it really gave the tools to the European Union to pursue an ambitious trade agenda. One of the tools includes the expansion of the scope of the common commercial policy. Another one is the consolidation of the international treaty-making procedure in Article 218, Treaty on the Functioning of the European Union. So with these tools at hand, the European Union has been pursuing a quite ambitious trade agenda and expanded the network of its new generation free trade agreements. These are the agreements that pursue deep and comprehensive relationship with third country partners. The first one was the agreement concluded with South Korea before the entry into force of the Treaty of Lisbon, but since the entry into force of the Treaty of Lisbon, the number of these treaties have really significantly increased. So in my paper, I survey these agreements, these new generation free trade agreements. And the second aspect that defines the scope of my study is the fact that the Treaty of Lisbon has also sought to improve coherence in the EU's international action. And this has been achieved by ensuring that all EU's external policies pursue the same goals and objectives. These goals and objectives are defined in Article 21, Treaty on the European Union. This article applies to all EU's external policies. It provides that all EU's external policies should be pursuing the same goals and principles that inspired the creation of the Union. They include or can be broadly classified under the headings of rule of law, democracy, human rights, and sustainable development. So we have heard today that the European Union is trying to restructure its identity on the international scene. Actually, if one looks at the EU's international trade action post-Lisbon, I really can't see any restructuring happening there. If anything, I think what is happening is resurgence of this narrative of normative power Europe. And it is the Article 21 Treaty on the European Union that is defining the normative identity of the European Union on the international scene. So, within the framework of these two things, the New Generation Free Trade Agreements and Article 21 Treaty on the European Union, what I look at in my paper is the role of the European Parliament in realizing this normative identity of the European Union, in helping the European Union to realize these objectives in Article 21 through its participation in the process that leads to the conclusion of the New Generation Free Trade Agreements. Now, the European Parliament makes an interesting subject of a study at this moment in time because before the entry into force of the Treaty of Lisbon, it had absolutely no power to be involved in international treaty negotiations apart from the power to be informed. And since the entry into force of the Treaty of Lisbon, as you can see on the slide, the Parliament's powers have significantly increased. So first of all, in accordance with the provision of Article 207, Treaty on the Functioning of the European Union, the Parliament, alongside the Council, is a co-legislator for a framework for implementation of the common commercial policy. It also has a right to be informed. The most important right of the European Parliament now comes from Article 218, Treaty on the Functioning of the European Union. This article gives the European Parliament power to consent. So the European Parliament has to consent to the conclusion of any international trade treaties. So now we are celebrating 10 years since the entry into force of the Treaty of Lisbon, and my paper surveys how the European Parliament used these new powers in order to shape the EU's international trade action. Now, another reason why the European Parliament makes an interesting subject of a study is that since the entry into force of the Treaty of Lisbon, it is the European Parliament that is the only source, or the main source, of the democratic legitimacy, is the only institution that provides democratic scrutiny of the EU's external trade action. This is mainly due to the expansion of the European Union's competences, the expansion of the common commercial policy. As has been confirmed by the Court of Justice in Opinion 215, the Union's competences in international economic relations encompass almost the entire field of international economic relations, just with the exception of non-direct foreign investment and aspects of investor-state dispute resolution system. So in many cases, in particular in cases of deep and comprehensive trade agreements, it is no longer necessary to engage national parliaments in the ratification process of these deep and comprehensive trade agreements. And we saw that, for example, recently with the conclusion of the EU-Japan Economic Partnership Agreement, which was ratified as EU-only agreement and took only 5 months, with the European Parliament providing democratic legitimacy in the process. So as this layer of national democratic scrutiny goes away, it is the European Parliament that provides that is the sole source of democratic scrutiny. So it is also solely in the hands of the European Parliament to represent the voice of the European citizens in these trade negotiations. And I think that this is really important today, that the voice of the European citizens is represented at the international level. What we see on the one hand is the framework for international economic relations expanding, the cooperation between the countries deepening. It encompasses more and more areas and often involves regulatory convergence. As a consequence, these treaties affect the lives of the European citizens to a greater extent than their predecessors, which highlights the need for their voice being represented in these negotiations. And also, we see that these deep and comprehensive treaties are increasingly contested by the civil society. What you see on the photo here are the protests in Berlin in 2016 against the negotiations of CETA and TTIP. So it is very important. The European Parliament plays a very important role here of representing the voice of the European citizens. And finally, as I argue here, as I argue in my paper, I see the role of the European Parliament as safeguarding these values and principles that are enshrined in Article 21 Treaty on the European Union. The values such as democracy, rule of law, human rights, and sustainable development. I argue that these values should provide a framework for the European Parliament in exercising its functions of providing democratic scrutiny to these deep and comprehensive international treaties. So, since the entry into force of the Treaty of Lisbon, the European Parliament has been incredibly proactive in contributing to the process that leads to the conclusion of the New Generation Free Trade Agreements. Thank you. It contributed virtually at every single stage in the negotiations. In the opening, in the negotiating stages, it made submissions to the opinions that were pending before the Court of Justice. It made contribution to provisional application and concluding stages using different tools. So at each of these stages, the Parliament would definitely issue a non-legislative resolution that states its position. There will be individual members of the European Parliament that will be posing questions. And of course, at the final stages, the Parliament provides its consent in a legislative resolution. The opening of the negotiations is a good example of the potential of the European Parliament in these trade negotiations. So here the European Parliament really made the impact to influence the constitutional practice. Before its participation, the practice was that the Council would conclude a mandate that was confidential and transferred only to the Commission. The Parliament, through its non-legislative resolution, put the pressure on the Commission and the Council to ensure that, first of all, the mandates are made available to public, and secondly, that they are not adopted until the European Parliament expresses its position on the mandate. In the beginning, this was a hard sell, especially to the Council that preferred secrecy at this stage in the negotiations. But at the moment, 10 years on, we can really see this being the norm in the practice of concluding of New Generation Free Trade Agreements. As for the substantive contribution, so for the purpose of my paper, I've analyzed about 13 New Generation Free Trade Agreements and different and non-legislative resolutions adopted at different stages in these negotiations. Looking at the substantive contribution of the European Parliament, the Parliament certainly emerges as the guardian of the non-trade related goals, values, and principles. So it frequently reminds the European Commission in its resolutions that actually market liberalization, that trade should not be a goal in itself, that the European Union should be using its trade policy to pursue also other aspects such as promotion of the rule of law and democracy, for example. In addition, in its resolutions, the Parliament don't only mention all these values in abstract, but doesn't shy away from mentioning specific issues that are pertinent within a particular negotiating context. For example, in relation to Colombia, it raised the problem of social cohesion and drug trafficking. In relation to Ecuador, the issue on the table was deforestation. With Japan, it was the ratification of the core ILO conventions. With Australia and New Zealand, rights of indigenous people. So through its substantive contribution, the Parliament contributes towards this, shaping this identity of the European Union as a normative power in international relations. It certainly puts that pressure onto the Commission in negotiations. And also the Parliament doesn't really want these values to be just aspirational. It also supports an effective inclusion of effective enforcement mechanisms in new generation free trade agreements. And recently we saw the European Union opening an enforcement proceedings against South Korea for non-ratification of one of the ILO conventions. So it is not, these values are not just aspirational. I think with the entry into force of the Treaty of Lisbon, we really see the European Union being serious about all of them. With this slide, I'm going to conclude, but I also identify some areas for future development of the role of the European Parliament in international trade. So whilst with its substantive contribution, the Parliament defends the values, it makes a meek reference to Article 21 in its resolution. So it mentions it somewhere in the beginning, but actually it doesn't use the provision to anchor its position or it doesn't use it as a framework for its contribution. And I think that it is because the Parliament is still trying to assert its position in negotiations and doesn't try to overly politicize trade negotiations. So I think the impression that I got through analyzing all these different non-legislative resolutions was that the Parliament still values the trade liberalization as the primary goal of the European Union's policy and is willing to sometimes maybe sacrifice other values in the process, as we saw with negotiations with Vietnam, where the Parliament recommended conclusion of the treaty despite serious political problems in the country, with dissidents being jailed without legal protection. In terms of position of the European Parliament, some improvements were suggested to its powers at the beginning of the negotiations. Some scholars suggest that the Parliament should be given consent powers to open trade negotiations. I'm quite skeptical about this improvement. I think it could prevent the Parliament from mentioning difficult issues at the outset of negotiations for the very reason of not politicizing the negotiations, but certainly consent of the European Parliament to provisional application is something that would improve democratic legitimacy of the entire process. Going forward, the biggest challenge for the European Parliament will be to assert its role in the implementation of the new generation free trade agreements. There will be a huge workload for the European Parliament, and the constitutional practice is not really solidified yet. So, thank you very much.
Thank you. So now I'm inviting our last speaker from this panel, Mrs. Anna Bishvizi from the Dairy College, American College of Greece, to delight us with her presentation entitled Artificial Intelligence and Geopolitics, EU Values, Freedoms, and Principle in Focus.
Can we put like a slide of the conference? This one, put this one. Yes. Thank you very much for the opportunity to speak to all of you. A big thank you to the organizers for making this big event happen. and to you that you've been through the day and you are still listening to me being the last speaker during this session. I'm very sorry that I haven't got slides to entertain you. This is like a long story. Had I had Alexa, like artificial intelligence, most probably she would have reminded me that I should have taken this USB stick with me, but she hadn't because I haven't got Alexa. Now, I want to talk about artificial intelligence and geopolitics / issues to be considered from the ethical perspective, and there are many of those. But before I start, I also wanted to ask you how you feel about artificial intelligence. If someone asked you, so this is like a test that I did to my students. I asked them, so because they always play with their phones. So I told them, all right, so now teamwork. And please name 5 technologies that you think are the most important ones, the most fancy ones. So they did it. And then I told them, and now on the scale from 0 to 10, please tell me how much you know about this, but please be honest. You don't have to tell me. And then it turned out, actually, they honestly said that they didn't know anything about. They may have known something about IoT, but they didn't know anything about BOT, and they didn't know anything about artificial intelligence. And it's quite all right. I mean, how can we know about this? These are really technical issues. So at some point, I really wanted to figure out what this artificial intelligence actually is. So I devoted a lot of time to studying the technical details. Do you want to hear? Just a little bit, I'll tell you. Because why do we actually call it artificial intelligence? It was already back in the 50s that some researchers, they wanted to do something that would resemble the human brain, hence artificial intelligence, which was in essence about machine learning. But why machine? Well, because it was all about the computer, and computer was like a machine filling the space, like the whole room here. So how could they possibly teach the machine? Well, they could only teach the machine by inserting in the system certain pieces of information, but these pieces of information would already be labeled. That is, the machine would kind of know how to organize it and systematize it, because we would have told the machine beforehand how to do it. And this is the so-called machine learning, the so-called supervised machine learning. The difference between what we had as artificial intelligence back then and today is that today, when we talk about artificial intelligence, we essentially talk about unsupervised learning and so-called deep learning. So what's that, I thought? I just didn't know what's that. So this unsupervised learning essentially allows the machine to take all this set of data that is unsystematized, unlabeled, untagged, and somehow cluster it or organize it in a specific way, then still make sense out of it. But in order to be able to make sense out of it, this computer needs to have a good algorithm. So you already see that there is kind of a problem. You have to have a really good algorithm. And then another thing is that you need to have a machine that has this huge processing capacity. So whenever we talk about artificial intelligence, we also talk about an entire ecosystem of technologies that have been in the process of developing for a number of years now. And the major difference, and to remind Commissioner Kroes, when she was talking about Intel and this tiny chip, do you remember this video from competition policy, right? Basically, the idea is that we have developed new technologies in line with which the tiny chips can measure information and tact in time. Therefore, they can refresh the information they have much more frequently than in the past. And therefore, all calculations that those tiny chips take place much faster. It's also an interesting point. It doesn't make any difference to the chip whether it's calculating towards the back or towards the future. This is why the predictive power of today's processors. But you know, the processor and then computers, so as artificial intelligence, whatever it will be, it doesn't really know that it is thinking in the future, so that it's predicting, the same way as it doesn't understand the difference between thinking in the future or thinking in the back, in the past. So I would like to draw your attention, I'll stop the definition of technicalities, but there are several misconceptions about how smart artificial intelligence actually is. But let me tell you one more thing about those concepts. We frequently talk about artificial intelligence in connection to deep learning. So what's that? So if you already have those very smart processors, and if we put them in a system, and in this set of processors has access to the memory of the computer, this will be like a network. But artificial intelligence is only as smart, as rich, or as big the capacity of the specific layers of processors is. So this is why we have layers of the sets of processors, one and the other. And if we have a good algorithm that would allow them to exchange information in between, this is precisely where the term deep learning comes from, because the information travels inside and back, while each of the networks has access to its own data set information. And this is where this artificial intelligence comes from, and these networks are called artificial neural networks because they are about to resemble our brains. But that they are not our brains is depicted by the fact that if several researchers tried to train neural networks to think like humans, they would fail. So for instance, there were some researchers who would feed the specific memories of computers from which those neural networks would draw with information about different kinds of ice cream. So be it strawberry, be it cream, be it chocolate, and so on. Then there would be a specific neural network that would be equipped with all information with colors, another one with tastes. And then if you would like to come up with a recipe for ice cream, you would actually come up with things that do not make sense. So this is the thing. As long as we do not tell those neural networks how to put things together that it would make logically sense, they will not know. So essentially, rather than thinking that the problem with artificial intelligence is that it is so smart, actually the problem is that it's not smart enough. And this is an issue that we'll come up with when we'll start discussing the issue of those killer robots. So I'm going to get there. So what is the impact of artificial intelligence on our daily life? Are you using it actually on a daily basis? Oh yes, you are. So how many of you have been texting today on Google? And how many of you were suggested how the sentence will end? This is precisely one of the techniques. Artificial intelligence also uses this natural language processing, like recognition of text. What is it that you would have imagined? What is it that you would have thought? And what is it that you would have written? Which is essentially based on statistics. So probability and those tiny trees that we're drawing at school, the machine can kind of do it. Now, another example. At some point, Google made a big purchase, like $500 million purchase. They bought the company DeepMind. What is it that DeepMind did? DeepMind essentially was able to create a program that would be able to play the so-called game Go, which is a Chinese game of 3,000-year tradition. And they were able to make a program that would essentially beat any player. And this game is said to be strategic, is said to be so complex that no one could possibly ever win with the best player. And yet they did it. And what they did, they simply developed several layers of processors. They equipped with all possible information, but then they also added probability into it. And this is how they developed so-called perfect program, drawing from the premises of artificial intelligence, was able to beat the best player. But if you would ask then the same system, so what is Go, or this game, it would know what it was. The same way as it wouldn't know that it wasn't played with a human being, or maybe with another computer. So it's just for you to have an idea of what's happening. Now, what about the economic impact? And I would like the chair to remind me of the time. We definitely see two very interesting issues happening. So on the one hand, we see the leading countries that are investing in the development of technology related to AI. And if you look at the most recent statistics regarding patents in AI, those that were released, let's say, in 2017, you see that Japan is one of the major producers of patents. But I think that this statistics is very misleading because essentially if you look at the cycle of patent development, let's say application and then granting of patents, basically you are talking about issues and processes and research that were taking place in the past. So in order to understand who is really the leader in the field, we will have to see the next 2 or 3 years statistics to see who really is in the lead. So this is one thing. Also, if we look at the patents categories, sometimes several patents that are quintessential for the use of capacities that we associate with artificial intelligence will not necessarily be directly categorized as those related directly to AI. So this is why this kind of statistics are still misleading, is one thing. But still, there are countries that have greater financial capacities and greater research capacities, and as a result, they produce more technology, and therefore we see a development that all economists know as the first mover advantage. That is, those companies originating from countries where the business environment, research environment is friendly enough for them to develop, they enter the market first, they are able to grab the opportunities first, basically leaving no space for anyone else to join the market as well. So we see a problem here. In the global scale, it might lead to polarization of the world, one thing. But there is another very interesting thing that we are observing, is that contrary to what we have been observing with regards to globalization and liberalization of trade, where progressing liberalization, a reduction in barriers of trade would lead to opening of markets and greater complexity of value chains and so on, and basically therefore globalization. When it comes to technology, what we see is that we essentially have a form of nationalisms re-emerging, because if we develop technologies, we want to keep it at bay in our country, we want to develop it in our institutions, we do not want anyone else to have access to it. Rather than sharing and reducing the barriers of entry, we are erecting new barriers. So the case of Huawei is a very good example. But there are several other examples that will definitely pop up anytime soon. So for all those who think about global economy and laws and how we are going to think about it, it's something to think about. Another issue that I see emerging, if you remember in 2016, during the NATO summit in Warsaw, cyberspace was defined as one of the theaters of combat. Clearly, artificial intelligence is also something that will be used in cyberspace. But I think we have a major issue to resolve at some point. If politics and geopolitics is all about geography and how we define and how we master our relations vis-à-vis others, and how it's then depicted in the influence we have on really tangible space, so geography. If we talk about cyberspace, how do we define our spheres of influence? How do we actually define that space? Because when we talk about tangible space, geography, we say, well, this is my border, this is your border, this is a river, this is a sea. In cyberspace, how? We just say, all right, we have cyber war, we have a cyber attack. But beyond that, so with the progressing development in the field of AI and ever new applications, possibly also robots and new forms and tactics, this will be one of the issues that we will have to discuss. So to recap, when my time is over, we have the new commission, and von der Leyen, she promised that within the first 100 days of her in power, of her in position, she will be able to produce some rules on AI. Of course, it is impossible. Possibly within the 101st days, so in 3 months from now, she'll be able to come up with a consultation paper. So I'm really looking forward to see what will be included there, beyond issues of privacy, human rights, and democracy, but also issues pertaining to what lawyers would be able to define with greater precision than I am. Thank you very much.
So now we shall proceed with the questions. Are there any questions from the audience? Yes, please.
I will have a comment maybe and a short question to Professor Ania Visvizi. Ania, 2 weeks ago I was on the seminar in Gdynia, in Technology Park on artificial intelligence. And I was wondering if your opinion, am I correct, did I understood you correctly? You are more in favor of liberalized attitude towards artificial intelligence, or maybe some protection of member states' interests?
Right. All right. Thank you very much. In general, I believe in equal opportunities for all. So in the debate on artificial intelligence, we have like the 2 poles, AI for good or AI for bad. Mm-hmm. We should be able to make sure that the benefits are shared equally. So what we see now, this return to nationalisms, I do not see it a good thing. Because already the example of Huawei suggests how dangerous a tool it can be. So just to give me an example, Trump is so much against Huawei. seeing in Huawei a tool of Chinese
Influence.
influence in the United States. But then think of Oregon and the farmers who have invested in the Wi-Fi and broadband network based on Huawei. What are they to do now?
Okay, I think that the case of United States is very difficult to analyze. But from my point of view, actually, in accordance to what I said during my panel, that there are some areas that should be taken into consideration in terms of safety of public order. And I think that new European Commission will go into the direction of protectionism of the European interest. In case of what you mentioned about the innovative position and advantage position, which is the result of the implementation of artificial intelligence, I think that this is a natural process. We have something to do like the cycle of technology, and we have those imitators, leaders of innovation, which of course have the the most advantage from their comparative situation in terms of competition in artificial intelligence. So I think that we will have a lot to discuss actually about those, your opinions in those terms.
Yeah, thank you very much. If I could pitch in the discussion and also include the panelists, the remaining panelists. So there is like another story. Particularly in the European Union right now, we see a major contradiction between our approach to research and our approach to competition policy. And now we see that these two fields have been actually put together, which is like a bomb in the making. Because our approach to competition policy, which essentially favors the consumer, discourages the first movers from being the first movers, which already leaves the European Union behind, with several companies that invest actually moving abroad, outside the European Union. So we see a major problem. So since we talked about how it looks in the field of businesses, so Dr. Godlewska, and since we talk about trade policy, trade and investment policy, by the way, so the question is to what extent the European Union would actually be able to push investment, so let's say maybe the European Parliament would be able to do something, and to what extent the business sector would be able to respond. I'm sure you have also good points on this.
Well, I'm not quite sure that we are quite there yet with pushing investment in specific sectors, with the European Union only gaining the competence in the field in 2009 and everything being quite a mess with ACMEA and Multilateral Investment Court, and I think there's still a lot of catching up that we have to do before we start thinking about encouraging investment and investment policy that can make a difference. So I would say nothing in the immediate future.
Yeah, I have to add something because I'm very interested in investment policy in European Union. And even Jean-Claude Juncker said in 2019 that we cannot be naive in terms of investment from third countries. So European Union cannot stay such open as it was before, because it is a naive attitude towards third countries.
In my opinion, as we talk about the sharing economy already have the solution based on artificial intelligence, because Amazon have the solution how to use drone to deliver the packages. The problem is the law, because the private property is protected not only in the treaty, but also in constitution of all member states. So how to use drone, how to define the air, who is a private or is the public sphere. So sharing economy have this solution, and when we change the law, European Union is working on the civil code for artificial intelligence, for robotics. In my opinion, I don't agree with Professor Visizi that artificial intelligence is only as smart as human who created, because Google was able to create 2 avatars who start to create own artificial language, and the creator couldn't understand how these 2 avatars communicate, and they cancel the research because they was afraid that they will lose control. So I think that now human artificial is able to be much smarter than human and will be able to pass, I think, soon the test, Turing test, if it is similar like people, if could feel, because I think when we talk only about not emotional intelligence, it has a problem to pass, but the intelligence, some analytical stuff, information, so it's much smarter. Only what is missing is this emotional intelligence, how you feel. So with this area, it's a problem. And it's huge debate about how we should treat the artificial intelligence, if we may sue it because we have a defective product directive, but this directive, what to do if something when go wrong with something. So it's based on old law. Now when artificial intelligence may be much smarter than human and independent of human who created, so it'd be a huge problem about the responsibility, not only civil responsibility, but also the criminal responsibility. In Switzerland, we have the police in Switzerland arrested artificial intelligence. So they arrested a computer because it was some happening, artist happening. They created a program and wanted to make some event about the things what artificial intelligence buy in internet. So they give the algorithm a money, and this algorithm should buy on auction on Amazon, eBay, different things, and they want to make the happening what artificial intelligence buy on internet. But the problem is that in very short time, artificial intelligence start to buy drugs or some weapons, and break the law. So the police arrested this computer, but they don't give any penalty for these artists who create this algorithm. So they punish not the creators of artificial intelligence, but artificial intelligence per se. So it's very unusual. And maybe the future will like that we don't only punish the creators, but also artificial intelligence. So we will arrest these programs.
Okay, so we will have time for one more question. Is it someone who wants to ask questions? If not, then thank you, and we can proceed to the coffee break.
Can you send me a word? Yes. Because I find it very, very interesting. Yeah, but the way you present the problem was very, very interesting. So if you already something that was ready. Okay, thank you.
Auditorium 1. Session 3. Session 2. Session 2. Session 2 auditorium.
It's not possible just to put it on the desk.
So you will see that it's on a desktop? It's
I
okay.
don't know if
No, but they will see it.
oh yeah, I understand.
So which one? Is this?
Yes, yes, this one, please.
Ania, będzie sprawa, słuchaj. Bo teraz ty będziesz
We can't find the right session, you know, so I'll put it on the prezentacja.
Okay. W tamtej drugiej sesji są łączymy. Ja zaraz przyniosę tam to
Because I did not find.
zrobimy po prostu.
But thank you very much for your help.
Tak? Czyli, że każdy miał z 10-12 minut na wypowiedź, dyskusja na koniec, czyli najpierw
We still have 10 minutes, no?
Yes.
So put yours as well.
Yep.
PECSA, trade policy.
So presentatia, it will be just here because we cannot find it. I mean, it's block C. It's auditorium 1, session 2. Session 2 is just A, B, but not C.
Okay.
So it's here. Okay.
Great. Thank you.
Aniupa, super. Jest sparring, dobry.
Ale to powoduje, że Komisja Warsaw mogła zacząć robić investment policy od razu. 2009 wchodzi, 2009 mamy propozycję, teraz mamy Akminie, 190, 190.
Gdzie my mamy sesję? Mamy gdzieś sesję?
Się z nimi pozbyć, tak, tylko to jest wszystko takie unijne, ale tak się zawsze działo.
więc tak, kochanie, zobacz, tak będzie...
Sobie robi straszny hałas i nie potrafię tego powiedz, kto jest kto.
Tu masz rozpisany nowy aktualny plan. Będziemy w takiej kolejności. Solange będzie, Karolina Sobczak. Okay. Karolina teraz. Zgraj sobie z maila swoją prezentację. Karolina Kowier tutaj.
It's just because we want some proof from the university that I was in the conference, so I'm taking a picture.
Więc wydaje mi się, że mamy...
Czyli zaczynamy od kogo?
So,
Po kolei, tak jak idziemy. 1, 2, 3, 4, 5.
can I take a picture?
Tak.
No.
Jest Zina tutaj. Aleksandra tutaj. Tak. I kończymy o 18.
Dobrze. Ale ja nie znam skądś.
Jest możliwe. Nie wiem skąd, Uniwersytet Warszawski.
Z widzenia.
Jestem doktorantką na Uniwersytecie Warszawskim.
Z widzenia.
A na Uniwersytecie Warszawskim może Pani miała jakieś...
ale świat jest mały, więc może Pani ma jakąś konferencję.
Jest to możliwe, a Pani dokładnie zajmuje się czym, czyli oprócz tej inteligencji sztucznej i tak dalej?
Tak naprawdę.
No, szczerze mówiąc,
Nie,
tak.
no, zajmuję się tym, tak, słuchaj, zajmuję się tak generalnie polityką, ekonomią i technologiami. I
Okej.
ograniczę wszystkim co, czyli to przypada też na
A Partnerstwo Wschodnie?
Kiedyś pisałam sporo o tym.
Bo ja właśnie piszę o tym doktorat. Czy ono jest w ogóle wartościowe, czy nie? Pod kątem raczej takiej ewaluacji, profesor Szypycki. No prawie to już koniec, ale i tak... No jestem nastawiona raczej w taki sposób pesymistyczny, ale to już zaczęłam ten doktorat, więc muszę w jakiś sposób...
Wybrnąć z tego.
Tak, tak. No mam taką analizę SWOT, coś tam pokazuję i tak dalej, ale też może, jeżeli by Pani miała kiedyś jakąś możliwość, to chciałabym po prostu porozmawiać.
Bardzo chętnie. Wiesz co, ja z tym, jestem Anią.
Dziękuję bardzo.
Partnerstwie Wschodnim, wiesz co, korzystam z urzędnikami. Miała Twój e-mail, to Ci coś przyślę, bo myśmy kiedyś, jest taka książka, ona jest cała online. Tam jest kilka dobrych tekstów, kilka pomysłów. Może Ci się przydadzą. Ale jest inny, który się podobał najbardziej, co było... Ja byłam do zeszłego roku redaktorem naczelnym tego Yearbook of Institute of East Central Europe. I w tym ostatnim numerze, który ja redagowałam, tam były dwa bardzo krytyczne artykuły o partnerstwie wschodnim. To tego chciała Ci przeczytać, czekać sobie przy Olga Bogorowa.
To ja może wpiszę, bo jest trudne. Nie mam żadnych... Sorry.
To cokolwiek byś chciała, po prostu napiszesz mi maila.
Dobrze, to ja może zapiszę Pani.
Tutaj zapisz, wyślij mi teraz. Napisz.
Okej.
Pan też prezentuje?
Po angielsku.
Alright. You also presenting?
I already did it.
You already did, right?
Yeah.
Because I'm supposed to be the chair. So I just kind of try to figure out who is going panel. Alright. Okay, so I have it. To mam w takim razie, Ci tu przyślę
To będę bardzo wdzięczna.
i napiszę jeszcze class EIP.
Do you have a legal background or engineering background? Because I could not
A bit.
Huh?
A bit, yes.
So have you ever heard of